Welcome to Dorsey & Whitney's webinar on securities fraud, the pandemic and compliance, protect your organization. I'd like to introduce Tom Gorman, a partner in Dorsey's Government Enforcement and Corporate Investigations Group. Tom?
Thank you, Sean, and good afternoon to everyone in the Eastern time zone. Good morning to those of you in the farther out time zones. As Sean mentioned, this is a program focused on securities fraud. Our goal here today is to try to give you an idea of just how broad and just how complicated this topic really is. The idea of securities fraud runs across pretty much every kind of practice of law that you can think about. It starts with a financial fraud. It can involve insider trading. It can involve cyber fraud. It can even cut across deals. And for that reason, what it takes is a team. And we've assembled a team of people to talk to you today about this that range from people in New York, our New York office, the Minneapolis office, the Washington office, LA, and Beijing, because that's the kind of team that you need to do this. This is going to be a video program. We hope the transmission will be live. We hope the transmission will be clear and that you'll be able to hear all of us very well. To facilitate your process here, we've also prepared a number of documents and some materials showing you what the SEC's been doing for the last few weeks and the last few months. You can download those at events.dorsey.com, and I think you'll find that they're a good complement to the program. But for today, let's get started on this. And at the end of the program, if there's time, we're going to try to do Q&A, but I doubt that we will have time. So just email your questions and answers to me, and I'll get them distributed and answered for you. So without further ado, let's start with our first speaker. Andrea Weschler is a partner in complex business areas of our firm. She's going to speak to you today about the necessity for creating a team to deal with this. Andrea?
Good morning, everyone. Before we dig into the issues, I want to talk to you about the teamwork that forms the foundation of Dorsey's work in this space. I played lacrosse for the George Washington University in college. I was a member of the inaugural team. And as a first-year team, we really had to work through figuring out all the challenges that we would face as a first-year team and how each of us could best serve the needs of the team to function and play at the highest collegiate level. In that process, I switched positions. Back in those days, I had some good speed, so I ended up moving from an offensive to a defensive midfield position to serve our defensive needs. My other teammates also relied on their respective strengths to tackle other challenges. That's similar to how Dorsey approaches securities fraud issues. We draw on attorneys with different expertise across various practice groups to form the right team of people to address the challenges and issues that can arise. In that way, we figure out who needs to be on the field, what roles they each will play, and we make adjustments when necessary. In my own practice as a litigator, I deal with a variety of commercial disputes, many of which involve some sort of corporate misconduct. I know that when my clients are facing regulatory or criminal investigations, I need to call in some other team members. And others in turn depend on me when things are in my wheelhouse. Now, why do we do this? We do this because fraud has many faces. It doesn't just take this one form. There are a lot of ways that fraud and also corporate misconduct can come up. Today, you'll hear about some of those different faces of fraud and corporate misconduct, including fraud by brokers and advisors, conflicts that breach fiduciary duties, insider trading, market manipulation, and cybersecurity breaches. Not only that, but these are all issues that are highly regulated by the SEC, by the DOJ, or by statute. There can be regulatory, civil, and criminal consequences. So the regulation and enforcement also has many faces and takes on many forms. We'll look at how the government uses its power to look at you, investigate you, and the consequences that that can lead to. So back to teamwork. Because the fraud and corporate misconduct that can result in government actions, it's not this one thing. It really takes a team of people collaborating with their wide range of expertise to identify, address, and respond to the various types of fraud and corporate misconduct. And now Tom will introduce you to some of those team members.
Thank you, Andrew. Really appreciate that. The next person that we've asked to speak is Kirsten Schubert. She is a partner in our securities and financial services area. She comes to us straight from having argued in the Court of Appeals on a very important case yesterday. Kirsten, welcome.
Hi, good afternoon, everybody. Morning for some of you, afternoon for others, probably evening even for others. I am a partner in our trial group here in Minneapolis. I do a wide range of commercial litigation, and I have significant experience in securities litigation, as well as other litigation in the financial services sector and some in the health industry sector. I need to warn you right now, I have a 7-week-old puppy in this room with me, and he was doing great until I turned on the computer. So I apologize ahead of time if you hear some whining, but that's what's going on. I know that we have many client lawyers on the line today who have significant experience with the mandatory reporting and disclosure requirements under the Exchange Act and the other hefty regulatory burdens imposed by the SEC. I am, however, here to tell you some bad news, as litigators are often forced to do, and that is that non-public companies and other executives should be thinking about this as well. The SEC's anti-fraud provisions are not limited, as many of us would like to think, to public companies. The key securities fraud provisions apply to all companies, whether private or public. In particular, Section 10b-5 of the Exchange Act and Rule 10b, Section 10b of the Exchange Act and Rule 10b-5 contain a broad prohibition on the use of, quote, any manipulative or deceptive device in connection with the purchase or sale of any security. The language of 10b and 17a is very broad and open-ended. The SEC prohibits fraud and imposes severe penalties for those who defraud investors or use non-public information. It encompasses any kind of fraudulent activity that may be in connection with the purchase or sale of a security. That can range. It goes from manipulating the stock market, making false statements that impact the market, and filing false information with the SEC. But conduct with non-public companies is also included. For instance, Theranos is a private company but repeatedly raised money in the private placement market. And part of that is that in 2016, the SEC announced that it was turning its attention to Silicon Valley startups in what it called the SEC's Silicon Valley Initiative. Mary Jo White, who was then chair, declared that it is axiomatic that all private and public securities transactions, no matter the sophistication of the parties, must be free from fraud, and that we must be vigorous in ferreting out and punishing wrongdoers wherever they operate. Law firms warned that unicorns were newly in the SEC's line of sight. Other companies can be involved with issues. Private company supplier that helps an issuer falsify its sales by participating in round-trip transactions, or other similar conduct can be an aider and abetter to securities fraud. Even private companies, if they're buying and selling firm shares among executives and others and making false statements, can have liability. In the past couple of years, the SEC has pursued a number of enforcement actions against both individuals and private companies related to purported fraud, even after Mary Jo White's tenure at the SEC ended. A couple of examples are Zenefits. In October 2017, Zenefits and its co-founder, Parker Conrad, settled SEC charges related to allegations that Conrad and the company misled Series B and Series C investors about the company's health insurance broker licensing compliance and failed to disclose violations in several states. There's Credit Karma. in March 2018, Credit Karma settled charges that it had unlawfully issued stock options to employees without providing appropriate financial information or risk disclosures. And in that same month, Theranos, which I just mentioned, the SEC filed charges against Theranos, its now disgraced and infamous founder, Elizabeth Holmes, and its former president, Ramesh Sunny Balwani, related to false product claims and overstated financial expectations. And I have to say, if you haven't seen the Theranos documentary, it is a great view, if for no other reason than it gives you some insight into what can happen to the rising Silicon Valley companies in that sort of environment, and is really an illustration about the kinds of problems that the SEC is thinking about in its private company enforcement actions. The SEC has even brought actions against private companies this year. Even when the SEC lawyers can't go into the office, I would have liked to hope that the SEC may have taken it easy in the face of a pandemic, but no dice there. Really, I think the important thing here, there's a couple important things. The SEC's latest actions against executives and private companies clearly have important risk management implications for private companies and for you all on the line who fit into that category. It is critically important that private companies and their executives recognize that they face potential liability exposure under federal securities laws for alleged misrepresentations to prospective investors and others, even if you're in the private market. The good news, however, is that there's not as much information out there about you. You know, you don't have the same reporting obligations as some of the public companies. So even though the anti-fraud provisions can come into the private sector, there is something lost in the SEC's ability to enforce. You can't use the anti-regulatory tool for mandatory disclosure and information from the market, and you can't look at the price and the other some of the other internal financial information that public companies might have on file. It's a low information regime, and it affects its ability to detect and punish fraud. I think that, like I just said, the takeaway here is that private companies and their executives need to keep an eye on their own conduct and think about their obligations under the Exchange Act, and take care of those anti-fraud provisions as they come up on a regular basis. So that's what I have, and I'm going to send it back to you, Tom.
Thank you, Kirsten. That was very informative. And just to reinforce what she said, in the last 12 months, the SEC has sued 4 private companies who did not raise money in the capital markets like Theranos did. And they have a COVID task force right now. And I can tell you it's active. They brought twice as many cases in the second quarter of this year as they did in the first. So our next speaker for this afternoon is going to be Dan Beisch. Dan is a partner in our New York City office. He, for a number of years, worked for Finra as an enforcement official there, and he now helps us defend enforcement actions, and more importantly, tries to show you how to do compliance so that you don't get that subpoena from the enforcement division. And while I have a lot of friends in that division, you really don't want to meet them. They're nice guys, but meet them for a drink, not professionally. So Dan, tell us what's going on at Finra, would you please?
Thank you very much, Tom. I wanted to talk a little bit today about Finra's focus on elder fraud. Finra takes elder fraud quite seriously. In each of the last 10 years, Finra has identified elder fraud and elder abuse as a priority item in Finra's annually released examination priorities guidance that is released at the beginning of each year. We're going to briefly look at the regulatory side of Finra, which has passed new rules and regulations targeted at protecting seniors. Then we will briefly look at the enforcement side of Finra and see how those regulations are being enforced. Finra established a dedicated helpline specifically for seniors in 2015 to provide investors with access to specially trained Finra staff who can assist seniors and vulnerable adult investors with questions or concerns about their brokerage account and about their investments. Additionally, in May 2018, FINRA, the SEC, and NASA, which is the North American State Securities Association, collaborated in getting the Senior Safe Act passed by Congress and signed into law by President Trump. In October 2019, Finra barred 2 individuals for their respective roles in churning accounts belonging to a 79-year-old customer who suffered from severe cognitive impairment. Finra found that from September 2011 through June 2012, the Forte Group, an entity Mr. Forte established in 2001, affected more than 2,800 trades in the victims' accounts, generating approximately $9 million in commissions. Over half these transactions involve short-term trading in long maturity bonds, including municipal bonds that were intended for customers with long-term investment horizons.
Dan, let me ask you this. Are there some steps that brokerage firms and investment advisors could take to try to avoid these kinds of problems and make sure that they don't have to go and use the hotline and don't have to go and get immunity?
Great timing on that question. In April 2020 this year, so after COVID, Finra issued a report that covered a 5-year period whereby Finra examined what the best practices were for a brokerage firm to comply with these rules and how the rules affecting elder law abuses had been working. In the report, Finra included specific examples of what were good written supervisory policies and procedures, what were good training requirements, what were good notification provisions. And they also included specific examples of how this worked. One that notably jumped out at me is as follows. Customer of a brokerage firm requested a $60,000 disbursement to an account in a different state to pay for the release of a general arrested in Afghanistan. The firm learned that this transfer was connected with the customer's romantic relationship with someone on an online dating site, and she had previously sent money from an account outside the firm. The firm placed a temporary hold on the disbursement and contacted Adult Protective Services and local law enforcement. She was found to have a cognitive disability, and her assets and monies were protected because this firm took the right steps and followed through. And as far as I know, the general's still in Afghanistan, if he even exists. Now, the helplines work, the regulatory initiatives, firm compliance programs, and senior investor stories described in that report really demonstrate the significance of Finra's commitment to protecting senior investors in the securities industry and avoiding senior abuse and senior exploitation. Finra does remain committed to addressing the risks relating to this and providing these resources to firms and senior investors.
Dan, that's terrific. And when we come to the end of the program, we're going to take the suggestions that you've given our listeners here for compliance and try to wrap them together with the other things that go with the various facets of securities fraud so that they can have a complete defense and not have these problems. But we thank you for that report. Really informative, really appreciate it. And by the way, for those of you listening, you should congratulate Dan because he's about to become a father. His wife is pregnant and she's due soon. Take care, Dan.
Thanks, Tom. Take care.
Our next speaker comes to us from our New York office. John Kaufman is a partner there. He specializes in dealing with offshore private investment funds, onshore investment funds, and other investment advisor type activities. John?
Thank you, Tom. In my segment today, I'll focus on private investment fund managers and how failures to disclose conflicts of interest to their investors may violate the anti-fraud provisions of the Investors Advisors Act of 1940. Section 206 of the Advisors Act prohibits investment advisors from employing any device, scheme, or artifice to defraud any client, and from engaging in any transaction, practice, or course of business which operates as a fraud or deceit. This section applies to all private fund managers, including both registered investment advisors and exempt reporting advisors under the Act. Section 206, in effect, requires an investment advisor to make full and fair disclosure of all conflicts of interest which might incline the advisor, consciously or unconsciously, to render advice that is not disinterested. In addition, Advisors Act Rule 2064-8 prohibits investment advisors to private investment funds from making untrue statements of material facts to their investors or omitting to state material facts. Okay, so how do private fund advisors make adequate disclosure? Key disclosure documents are the fund's offering documents provided by the advisor to investors and the advisor's Form ADV filed by the advisor with the SEC. All of these documents are scrutinized carefully by SEC auditors and compared against the advisor's actual practices. Advisors should regularly review and, if necessary, update their Form ADV disclosures of conflicts of interest, e.g. whether the disclosures are adequate, sufficiently specific, and follow the form's instructions. And how are the anti-fraud rules enforced by the SEC? SEC enforcement actions under the anti-fraud rules can result in massive monetary sanctions, even criminal charges in egregious cases. It is critically important to note that in anti-fraud cases under the Advisors Act, simple negligence can be sufficient for the SEC to bring an enforcement action. No showing of intent or even knowledge of wrongdoing is necessarily required. And it's tough to hide violations. Last year, the SEC audited approximately 15% of all registered investment advisors, and it intends to steadily increase that percentage. Keep in mind also that the SEC has a whistleblower program. Whistleblowers are eligible to receive between 10 and 30% of any monetary sanctions collected by the SEC for securities law violations. As you might expect, there's a cottage industry of lawyers that represent whistleblowers. Here are a few recent examples of SEC enforcement. In October 2015, private equity fund advisors in the Blackstone Group agreed to pay nearly $39 million to settle charges that they failed to fully inform investors about benefits they obtained from accelerated monitoring fees and from discounts on legal fees. A year later, fund advisors affiliated with Apollo Global Management agreed to a similar $52.7 million settlement. Then, just last year, the SEC brought an action against an exempt reporting advisor for failure to adequately disclose a conflict of interest with an affiliated broker. The fund's private placement memorandum disclosed that there was a potential conflict of interest insofar as the affiliated broker may receive fees or commissions in connection with purchases of securities by the fund. The use of the word may was deemed inadequate by the SEC in view of the actual agreement with the affiliated broker, which made payment of fees or commissions a certainty. This case is particularly important to fund managers because it highlights the need for very specific and targeted disclosure. If a private fund manager or its affiliates are receiving additional fees or other revenue from a fund's investment activities. Other proceedings in 2019 included enforcement actions for failures to properly implement valuation policies, excess management fees based on overstatements of net asset value of the fund, improper allocations of expenses to funds and between funds and co-investors, and conflicts in arrangements with third-party service providers. Less than 2 months ago, on June 23rd of this year, the SEC's Office of Compliance Inspections and Examinations, referred to as OCI, issued a comprehensive risk alert. The alert provides fund advisors with an overview of compliance issues observed by OCI in its examinations of fund managers. Some of the disclosure issues highlighted in the alert include methods of allocating investment opportunities among different private fund vehicles and among funds and their co-investors, special economic relationships with seed or anchor investors in funds, side letters granting investors special rights not disclosed to other investors, conflicts related to service agreements with affiliates, and conflicts related to fund restructurings, successor funds, and stapled secondary transactions. This risk alert is a valuable resource for all private fund managers, detailing as it does what the SEC will be looking for in future audits. Forewarned is forearmed. Tom, back to you.
John, thank you. One comment, I think you probably know, investment advisors are one of the favorite targets of SEC enforcement, and the Office of Inspections is coming after these folks. How do you construct an effective compliance program to save these people?
Lawyers are good at that. We will help you construct an effective compliance program, and there's an industry of compliance specialists out there also, outside the legal field, that assist advisors all day, every day in effecting compliance with requirements under the Advisors Act.
And we try to, don't you usually try to shape these around the risks for the particular organization, so that if you identify the risks, you can have a compliance program that should be effective? Do you agree?
Yeah, absolutely. Absolutely. The disclosure documents for a fund, of course, are heavily tailored and detailed for the particular strategy and the individuals and the planned investments of that fund. So it's usually easy to see where some of the risks are going to be. For instance, in real estate funds, there are generally a lot of services provided by affiliates of the advisor to real estate related funds. So very careful description of those relationships and the way fees are charged is essential.
Now we're going to turn to our next speaker, Tom Schweiker, who is from our Minneapolis office. He is head of our securities litigation and financial services compliance group. And he's going to talk to us about something that probably most of you have at least heard about: insider trading. Thomas?
Thanks, Tom, and welcome everybody to the speed run on insider trading. This is a topic of great complexity and importance. I'm really just going to discuss the basics with you today and give you some takeaways. I will say, however, that for most of us, most of the time, insider trading is something that you'll know it, or at least you'll know enough to ask questions about it. And if you're talking about trading in your own accounts, if you have to ask questions about it, unless you're a hedge fund manager or a professional trader, it's usually the best course of action not to trade. The SEC takes a very broad view of what is insider trading. And the SEC's view is often broader than what the law actually is. So even if you're on the right side of the law, you may find yourself on the wrong side of the hassle. So what is insider trading? Like much of what we've talked about today so far, insider trading is a creature of the anti-fraud provisions of the federal securities laws, specifically Section 10B of the 34 Act and Rule 10b-5. It imposes both civil and criminal liability for insider trading. Insider trading means you cannot trade while in possession of material, non-public information in breach of a duty of trust or confidence. The in breach of a duty part is what creates a lot of the complexity within the law of insider trading. In general, it means that you cannot breach a duty that you may have to keep information confidential, and you cannot breach a duty that everybody has not to steal information for your own personal benefit. Material means that a reasonable investor would find the information to have significantly altered the total mix of information in connection with the trade. And possession means that you have the information. And there's an important distinction between possession and reliance. If you have the information and you make a trade, you are presumed to have relied upon it. You cannot come back later and say, well, even though I may have had this information, I based my trading decision on these other factors. That's not a valid defense. One of the most dangerous things about insider trading is not just the trade itself, it's the reaction to the trade in response to questions from regulators or an investigation. And I'm going to use the classic Martha Stewart example. Martha Stewart did not go to prison for insider trading. Martha Stewart went to prison because she lied to the FBI when they showed up at her office with her attorney present about her trading in ImClone. Martha Stewart avoided a $45,000 loss with that trade and went to jail for 5 months for lying to the FBI. And one of the ironic things about that case is there is a lot of debate over whether what Martha Stewart did actually constituted insider trading. She did end up settling with the SEC, but I would argue that, that what she did was not insider trading. So it's important to have, if you do get a call from a regulator, it's very important to have a strategy and a clear strategy when dealing with regulators. I had a case where I represented a guy who was an employee at a publicly traded company. He was a very active trader, not just in his own company stock, but in all stocks. And he happened to make a large trade right before the announcement of the merger of his company. The SEC came calling, and the SEC did an investigation, and the SEC narrowed down its theory to a meeting of some of the members of the board at a local restaurant where they discussed the merger. And they could not place my client at the restaurant at the time, but it was a restaurant that he spent some time at frequently. After taking testimony on the record, both from him and from many other people at the company, we were able to convince the SEC that they didn't have a case, or at least couldn't prove a case. So again, it's important that if there is an investigation, that you have a clear strategy with how to deal with it so you don't end up like Martha Stewart. Some conclusions and takeaways. Review and follow your company's policy. If you're in a publicly traded company, your company likely has written policies and procedures around insider trading. So trade only during open windows or with appropriate preclearance, and follow disclosure requirements. If you are an officer or director of a company, or you otherwise have frequent access to material non-public information, consider establishing a 10b5-1 trading plan. That essentially puts your trading of your company securities on autopilot. So it takes away your discretion, and if you do it right, it can insulate you later from allegations of insider trading. Beware of tips. It's, again, often very difficult and complex to determine, especially in the tipper-tippee context, whether or not you have material non-public information in violation of a trust or confidence. And if you have to ask, don't trade. You do not want to get the call from the SEC on a weekday night at 9 p.m., which is what they do, out of the blue, and ask about your trade. That tends to cause a lot of anxiety. And finally, if you see something, you should report it. It's likely required by your organization under its policies and procedures. It's important for the integrity of your organization, and it may not always be easy, but it is the right thing to do. And with that, Tom, back to you.
Thank you, Tom. And Tom makes some really excellent points here that everyone should think about when you're constructing compliance. Don't play close to the line with material non-public information, otherwise known as inside information. They are very, very good at this. They had two guys in another case I know about where they couldn't put them together. They finally, after months, put them together by getting the tracks off of their subway cards and seeing that they went through the turnstiles together. The case was brought, and the victims and the defendants settled. So with that, think about it when you're doing compliance in this area. Now we're going to turn to another facet of securities fraud with Anthony Epps, who is a partner in our Denver office. He is a corporate partner, interestingly, not a litigation partner, and he's going to talk to you about manipulation in the context of a business transaction. Anthony?
Thank you, Tom. I get the privilege of speaking on a topic that's very near and dear to my heart as a transactional lawyer, and that is market manipulation. What's important about market manipulation is that the integrity of the financial markets is so important. It impacts individuals and businesses across the world. Individuals, it could be the 13-year-old kid like I was, who saved and mowed lawns and purchased shares of your favorite company, or a company whose brand that you respect, or people who work their whole careers at a company and they have their 401k tied up in investments, or to public companies. When your stock price is high, usually business is good. When your stock price is high, that means that it makes financings a whole lot easier. You get more opportunities to raise money. And it just really indicates to everyone that you're a good company. When your stock price is low or when it's falling, people get concerned. They start questioning whether their investment was smart. They start questioning whether they should sell their shares. And from a company perspective, when your share price goes really low, that could mean you may go out of business. Or even if that doesn't happen, you can be in a situation where if your stock price goes low enough, you may be subject to delisting from the New York Stock Exchange, NASDAQ, or any other exchange that you're on. So it's very, very important that the integrity of our financial markets is very important. But when I speak of integrity, I'm speaking of integrity in a very narrow context. Integrity in this context just basically means the price that you buy shares in a company or the price that you sell your shares in a company really is backed up by what the company is doing. It's not the price isn't artificially pushed down, and it's not artificially pushed up because the stakes are so high. So when we talk about market manipulation, all that is in layman's terms is just any concentrated or concerted action, whether it's one person or multiple people who get together and decide that they're going to sell or buy a large number of shares in a company to trick everyone else, to trick the rest of us into thinking that a company is really going downhill, so we sell, or the company is really doing great, so we need to buy. And what happens is usually after their illegal activities are done, that the stock price will either go back up naturally or it'll tank, and then you'll be left in a very difficult situation. So what a lot of the regulators do, specifically the SEC as the gatekeeper for investors, and to make sure that there's as level of a playing field as we can possibly have, it's very important to them that the markets have integrity. So one way that the SEC goes about policing the markets is through Regulation M. Regulation M is just a series of rules that dictates when market participants or deal participants can buy and sell securities up to and during the consummation of an offering. So what this means is that in the public company context, if you have a deal and you're using a broker or you're using an underwriter, whomever you're using, you're going to have situations where insiders, officers, directors, and even other people may say, hey, similar to what Tom was talking about, insider trading. Yes, that there can be an insider trading element to this, but Regulation M is really designed to make sure that the market maintains integrity during the deal process. One thing that some people don't realize with Regulation M is that it does apply to private deals as well. So it applies to private deals when there's unusual kind of selling activities, and usually all that means is that you hired a placement agent or a broker dealer to help you sell your deal. So Regulation M is one tool that the SEC has at their disposal, and in order to try to maintain the integrity of the financial markets. But the difficult reality of market manipulation is that when a lot of us think of market manipulation, we think of these really advanced and super complicated schemes. But in reality, that's not always the case. One of the latest and I'll say greatest in a joking way, but one of the latest techniques people use for market manipulation is a technique that we call ghosting. Ghosting in this context, all it means is that an individual or a group of individuals get together and they open up two separate accounts. They open up a buy account and a sell account. And what they'll do is they'll target companies who have very thinly traded shares. So it could be a company on the OTC market where the trade of 100 shares or even 1,000 shares a day can have a real impact on your share price. So what these people will do is they'll buy shares in advance. Then all of a sudden one day they'll just sell those shares. And when they sell those shares, the market price for that company's stock, it goes all the way down. And so when the stock price is at its lowest point, then they'll turn around with their buy accounts, but buy the shares at the lowest price that they can, buy a bunch of shares. Then when the stock price rebounds, that they end up selling the shares that they bought, and they end up getting a gain. It's a new technique. It's not super sophisticated, but it's very difficult to track. It's very difficult to figure out who's who. That the SEC brought an enforcement action late last year against a group of Chinese investors who had tried to do this, and they ended up getting a net profit of $30 million. So it doesn't take the most sophisticated process or techniques in play to manipulate the market. So when we think about companies, the best thing companies can do is utilize software which tracks any sort of unique trades that are happening or unique market activity. And when they notice something going on, reach out to their lawyers, or even reach out to the SEC, Finra, NASDAQ, NYSE. All these institutions care about market manipulation. So Tom, back to you.
Thank you, Anthony. And this again is another example of just exactly how broad securities fraud really is. It's not just insider trading. It's these kinds of transactions. And Anthony's point is a really excellent one, because not only will the company be involved in this, and not only should the company monitor itself and report if it finds something, also the professionals. There's a theory called the Gatekeeper the SEC uses. They expect professionals, lawyers, accountants, and other market professionals to monitor transactions and to keep them in line. And if you don't, not only will your client get the subpoena, the lawyers will get the subpoena too. So something to watch out for. Next, we're going to hear from Nick Ackerman. Nick is a partner in our New York office. Nick is a nationally known litigator. He was a former Watergate prosecutor, and he's going to talk to us about cybersecurity, a very important topic these days. Nick?
Yes, cybersecurity is one of the more recent areas that now involve securities fraud. And failures in cybersecurity can form the basis of an SEC investigation into securities fraud. The SEC now recognizes the theft of either personal or competitively sensitive data by either hackers or outside insiders. Corporate insiders can have a material impact on a company's operations, its profitability, and its shareholders' value. The worst case scenario here is something that happened with respect to Yahoo back in 2018, when it was fined $35 million by the SEC for failing to disclose what became a massive data breach. Now, the SEC has a robust program on cybersecurity. The SEC has adopted the national regulatory trend away from a reactive to a very proactive approach to cybersecurity. Companies are not only required now to notify consumers or shareholders when there are material effects rising out of a breach of data, but they're also required now to proactively protect data in the first instance to protect against a data breach. Now, the key to this proactive approach is a company-wide data compliance program overseen by the board of directors and top company management. The SEC and other government regulators are in effect requiring companies to have in place a data compliance program. You can incorporate a data compliance program into what you already have, but it's basically trying to protect both the personal and competitively sensitive data. To institute an effective compliance program, you need to follow 7 steps that are outlined by the government. One is developing standards and procedures, letting your employees, company executives know what the rules of the road are. 2, assign a person with overall responsibility who reports directly to the board of directors and possibly the audit committee, and to finance the effort with the appropriate amount of funds that are proportional to the risk involved in that particular company. 3, you have to take care not to assign anyone to this program who might pose a risk to the company. 4, it's extremely important to communicate the standards and procedures, basically company-wide training so that everybody from the top down knows what the rules are with respect to protecting the company's data. 5, to have regular audits such that you know on a regular basis that the program is working and where its deficiencies are and how you can improve upon it. 6, to constantly enforce those policies and to consistently enforce those policies so you have a uniform basis across the firm. 7, to institute a mechanism in place to respond to violations by having an 800 number so people can report information confidentially, have an ombudsman or somebody else in a supervisory capacity that can take this kind of information. Now, these 7 steps are set forth in the federal sentencing guidelines, and these 7 steps were initially set up as a compliance program to mitigate corporate criminal penalties, but has now become the gold standard in compliance in the United States and many other foreign countries. Now, when I approach this issue for clients to develop an effective compliance program, my first task is to gather in a room all of the stakeholders who have an interest in protecting the company's data. And that means not just IT security people, but in-house legal counsel, HR professionals, risk management, and design the compliance program that fit the unique risks posed to the company. The bottom line is, with an effective data compliance program, not only will you comply with the SEC's requirements and avoid any issues with securities fraud with respect to this issue, but you also avoid having to deal with all the state and federal agencies that are currently playing a role in dealing with the protection of data.
Thank you, Nick. We really appreciate that. One quick question. You mentioned HR department. Why do you want them there?
Well, HR actually plays a very key role in protecting data. HR sets the rules. I talked before about having a code of conduct. They set the rules. Of course, they do this in concert with the lawyers, but they put those rules into the handbook, the employee handbook. They enforce those rules. And again, this is another area where data compliance is a team sport. It involves the IT security. You've got to consult with them when you formulate these rules. And you also get input from the board of directors. HR is where new employees come into the organization. It's the point at which they're told what the rules of the road are. It's an opportunity to make sure that employees don't bring into the workplace data from a competing company that may create criminal and civil problems. HR is also the place where employees leave, and it's an opportunity to explain to employees when they leave what the rules are with respect to leaving data behind and making sure that data is accounted for. A lot of times HR participates in investigations into data breaches, particularly when it involves insider employees, if somebody is going to leave the company to work for a competitor. So HR, just like IT security, just like legal, they're all integral parts of making a compliance program in this area extremely effective.
Great point, Nick. Thank you very much. Really appreciate it.
Thank you, Tom.
Our next speaker is Ray Liu. He is the head of our office in Beijing, China. Ray is going to talk to us about identifying red flags in the context of trying to figure out what happened in a securities fraud case. Ray, thank you for being here.
Thank you very much, Tom. Thank you. It's my great pleasure and privilege to address this distinguished audience today. We're live here from Beijing. So I'm a partner of Dorsey Whitney LLP and the chief rep and managing partner of Dorsey's Beijing office here in China. Actually, I'm wearing another hat today. I was a former in-house counsel at the Bank of China New York branch, dealing with, among other things, fraud investigation matters. Actually, I was involved and pretty much drove the process of setting up internal fraud investigation intake and handling system at the bank, drafting protocol and policies, and dealing with victims and law enforcement agencies of wire fraud and other fraud activities in which the bank got involved. So the topic I'm covering today is discover and identify if you have security fraud, as Tom just mentioned. So I'm going to address this topic in two parts using this, external and internal fraud dichotomy. So let's talk about external fraud first. So there are 8 high-level tips I'm going to share with you today in terms of how to identify red flags, warnings of investment fraud, or how to discover whether this investment scam, which are pretty much in line with various SEC guidelines issued over the years. So 1, inflated performance claims. Does the offer sound too good to be true? Typically it is. So be skeptical. 2, guaranteed returns are not, right? Same for institutional and individual investors, almost like a general rule of thumb. Low risk generally means low yields, right? High yields typically involve high risk, right? Too many fraudsters just spend hours and tremendous efforts trying to convince the investor that, extremely high returns are quote unquote guaranteed. Well, they're not, especially for OTC bulletin board and pink sheets traded stocks. They're inherently very risky options, right? And more susceptible to, human manipulations. 3, is the seller using high pressure sales tactics? Be careful. 4, never invest in security markets based on, very fancy websites and marketing materials. Always check out, some third-party resources to double check and verify, which leads to, naturally, number 5, research, and research. Do our homework, right? Do some sufficient due diligence over the security investment opportunities, right? Check out the financial statement of the company on SEC website, state securities, regulators website, etc. And also check out whether it's properly registered or legally exempted from registration. 6, verify the credentials of the brokers and advisors. Knowing them personally is not enough. 7, be extremely cautious of unsolicited offers, right? You usually receive those by emails. When I was an in-house at Bank of China, I've dealt, just a lot of them. Just some of them are just, regular spam. You can identify them, pretty no-brainer, right away. But some are, to be honest, pretty sophisticated, requiring days and weeks and even months of investigation and verification with local authorities, other financial institutions, and a lot of other parties. 8, importantly, offshore investment opportunities. Wow, we have to be very careful about that. Always check out the local law requirements, registrations, get a local counsel in those relevant offshore jurisdictions, right? Verify the identity of the company and be very careful with, whatever terms and conditions that are out there, right? Reps and warranty, disclosure, conditions, governing law, dispute resolution clauses, and translation issue is an important one, right? Sometimes in the English version of the materials look fine, but when it turned out to be the case that the French, Spanish, Chinese version of the materials is completely a different story, right? Obviously, one version just got manipulated, right? So always make sure that we check the translation. So literally, I'm going to just spend a minute talking about the internal or employee fraud, right? Purely internal issues might result in security fraud claims subject to company or organization, to huge liabilities. Sometimes, the cyber fraud grabs the headlines, ooh, big issue, but in reality, most prevalent form of fraud is internal. Some common types of internal investment fraud include asset misappropriation, bribery and corruption, data theft, payroll fraud, vendor fraud, and importantly, accounting fraud, just like the lock-in coffee scandal that we have all witnessed in the first half of the year. So how to deal with that? We have to build a very robust compliance system, have protocol in place, conduct regular and surprise audits, conduct training. And so by doing that, we can capture the red flags, spot the issue, and address them before it's too late. For example, some of the red flags include, employees who have something less than arm's length relationship with a vendor or a supplier, employees living obviously beyond their means, just to name a few. So if an employee is being investigated for internal fraud, just make sure that that person's access to critical systems of the company got suspended until we sort things out.
Ray,
and also,
Ray,
and you for instance, yeah, go ahead, Tom.
Ray, these are really great points. Do you suggest that these get wrapped into your compliance program?
Yes. So I would say guided by a combination of using the professional judgment, being skeptical, using the guideline from SEC, regulator, external counsel, and building a robust compliance system. And importantly, using our common sense. So we'll be fine. Yeah, thank you very much. Get back to you.
Thank you. Really great points. Our next speaker is Jay Jackson, who is a partner in Minneapolis. He's going to talk to us very briefly about the ruling in Blue versus the SEC, which came down in mid-June, and which I think the SEC doesn't like much. Right, Jay?
That's right. And first and foremost, I want to make certain everyone understands that the Liu involved in this case is not Ray Liu, who just preceded me, and is not related to him. My topic's going to deal with enforcement, the powers of the SEC, were they to bring a proceeding against somebody for recovery in this particular circumstance of profits, ill-gotten gains that they got through violation of the securities laws. The particular provision I'm talking about is 15 U.S.C. section 78D5, and it provides in pertinent part that the SEC is entitled to seek and a court is entitled to allow the recovery of equitable relief for the benefit of investors, equitable relief for the benefit of investors. Traditionally, and for decades before this decision, the SEC had sought gross profits, that is the entirety of the ill-gotten gains obtained by the wrongdoers as a result of their improper activities. On June 22, in an 8-1 decision, the Supreme Court decided that the SEC was entitled to seek and a court was entitled to award only net profits, that is the ill-gotten gains less, that is to reduce it by the legitimate expenses incurred in the operation of the enterprises. Secondly, the SEC had typically sought to take whatever profits that they had obtained through this enforcement proceeding and deposit those in the U.S. Treasury. The Supreme Court focused on the language for the benefit of investors and required that as a part of the equitable relief allowed by this statute, that the ill-gotten gains recovered by the SEC needed to be paid directly to those investors and not deposited in the U.S. Treasury. Lastly, the SEC addressed but did not resolve the question of joint and several liability. If this was a group fraud, must the SEC provide proof of the ill-gotten recovery of each of the individuals, or may they apply joint and several liability? So the SEC got slapped on the wrist. They're still entitled to seek a recovery by disgorgement of ill-gotten gains, but they must net out legitimate expenses. They cannot deposit it directly into the U.S. Treasury, but must identify the investors who suffered the losses and provide the recovery back to them. Interesting question is going to be, and I'm going to leave you with this, is what is a legitimate expense for purposes of arriving at net profits? I think a fairly good argument can be made that if this is a fraudulent enterprise, no expense is legitimate. Back to you, Tom.
Thank you, Jay. Exactly right. This is going to cause the SEC a great deal of problems because it rejects what they've done for decades. Our final speaker today is Joe Liniak, who comes to us from Southern California. He is in our financial services group and deals with a lot of regulators that most of us probably don't deal about, including on money laundering. Joe, could you give us a very brief overview of an experience you just had with where you couldn't get any guidance from these guys?
Oh, well, good afternoon, everyone. I hope everyone and your families are safe and healthy. I want to talk a little bit and maybe bring this and point this out as a possible case study, bringing some of these things together and how it can affect advising in industry issues. And for purposes of this discussion, we're going to talk a little bit about advising the commercial cannabis industry. As quick background, the Federal Controlled Substances Act makes dealing with cannabis a felony, something very serious. And yet on the other side, practically every state now allows either medicinal or recreational use of cannabis. And even though the federal regulators gave a very, very soft safe harbor to allow providing financial services to cannabis companies, they were, if you will, focused on entities that touched the plant. But at the same time, over the last 5 years, the cannabis industry has transformed itself into an agribusiness where people are vertically integrating not only on a state-by-state basis, but on an interstate basis. There's billions of dollars of financing, which implicates securities companies. People are moving funds across state lines, all of which theoretically are violations of federal law. And yet it also implicates broker-dealers, investment advisors, banks, and so forth. Well, what we did is we went to FinCEN and said to FinCEN, can you give us some guidance in the area that really you haven't addressed in the past, because your guidance was focused in on entities that merely touched the plant, cultivating it, mowing it down, processing it, and selling it. And after about a year, they came back and said, we're not going to tell you anything. We are not going to give you any guidance, and we have no intention of giving any in the near future. However, we suggest that you follow the law. Well, that's not a very, very useful way of being able to advise and to consider in this very complicated area. And so what we have ended up doing is pointing out to clients who realize that they want to view this not from a criminality standpoint, but from a risk management standpoint, that they have to view it in risk management. And what my friend Nick Ackerman just mentioned, the sentencing guidelines, that's really very, very important. And we have told people that if you're going to be doing that, you have to look at those. You have to have an appropriate set of policies and procedures, commensurate with what your involvement is, because what that does is it minimizes intent to violate the law. And then if it ends up that the Department of Justice comes after you, you can say, we did everything we possibly could. You didn't give us any guidance, but we asked for it, and go on and bother somebody else. That's a really truncated version of what I wanted to say. However, it is the role of government to help us out in these very troublesome areas where there's an interstitial relationship between state and federal law as well as civil and criminal law. Tom, back to you.
Thank you, Joe. Very informative and shows you some of the risks that you're all facing here. We apologize for being a few minutes over the end, but we thought that these messages were very important to the overall discussion. And I think the point here is securities fraud is not what you think it is. It's incredibly broad, incredibly complicated. And what Joe was just talking about hits every kind of transaction in the form of money laundering. But the point is, it takes a team of people to figure this stuff out. You've seen our team, and we want to thank each one of those people for coming here and talking today. You're seeing the pictures put up on the screen. Everybody here made a huge contribution, and we appreciate most of all of you listening, taking the time. Have a great day. Stay safe.